3 months after I sentenced Caroline Mercer, I received a letter from Nina Alvarez. One sentence in that letter said, "She comes early now, and before the doors open, she straightens the chairs for the people who can't stand long." I read that line twice. I want to tell you how we got there. The letter was dated March 3rd, 2026. It was one page, written in blue ink, folded cleanly into thirds. Nina did not ask me to feel good about what I had done. She did not ask me to change anything. She only told me what she had seen that morning at 7:40 a.m. in the waiting room at Cumberland Family Care Center, and she trusted me to understand why it mattered. I want you to subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic. And those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. When the case first crossed my desk, it did not arrive as a story about care or chairs or anything gentle. It came as a misdemeanor file with 2 charges, a security still, a repair estimate, and a note from the clerk that said the defendant was requesting accommodation due to her husband's position. Her husband was Lieutenant General Thomas Mercer, still active duty, still known in the county, still the kind of name people think should open doors. The first hearing was on November 6, 2025, at 9 a.m. in Courtroom 3B of the Cumberland County District Courthouse in Fayetteville, North Carolina. Before I took the bench, Caroline's attorney asked if the case could be called first and whether she could enter through the side door reserved for deputies, people in custody, and those with a medical need. The reason offered was public sensitivity. I denied both requests the moment I sat down. I said Mrs. Mercer would use the same public entrance as every other person in that courtroom. I said her case would be heard in the order set by the calendar. I said no one in my courtroom moved to the front because of somebody else's rank, medals, or last name. The room got very still after that. Then I looked at Caroline for the first time. She was 47 years old, wearing a navy suit that had been chosen with care and slept in badly. There was a loose thread at the cuff of her left sleeve. Her right hand stayed closed so long I could see the pale marks where her nails had pressed into her palm. Before she sat, a legal pad slipped from the end of the defense table. It was not hers. She bent, picked it up, set it back in place, and only then took her seat. That small act stayed with me. People who expect special treatment usually move through a room as if other people are part of the furniture. She did not do that in that moment. She looked frightened, proud, tired, and ashamed all at once. I had not heard testimony yet. I was not excusing anything. I was simply noticing the person who had walked in. I learned the rest in pieces. Married 22 years. No criminal history. 2 grown sons in other states. For 8 months, she had been the main caregiver for her husband after a stroke that left him with memory gaps, mood swings, and a long list of medications that had to be managed by the hour. None of that erased what she did. It did tell me that if I wanted to sentence her well, I needed to read slowly. Nina Alvarez entered through the public doors a few minutes later. She was 34, a pharmacy supervisor, wearing a black wrist brace on her left arm and carrying a folder with color tabs. Before she sat down, an older man with a cane paused in front of her row. She stepped back, let him pass, and waited without making him hurry. From the bench, that kind of thing is easy to see. What I noticed most was where Nina did not look. She did not keep staring at Caroline. She looked at me when I spoke. She looked at the exhibits when they were shown. She looked down when she needed a second to steady herself. That told me she had not come to put on a display. She had come because something real had happened to her and she wanted it handled cleanly. When she finally spoke, she said, "I do not need this court to prove to me that what happened was wrong. I know it was wrong. I need this court to make sure she does not get to hide inside who her husband is." That sentence was careful. It was also true. Nina was not asking me to destroy anybody. She was asking me to look straight at the actual harm. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. The incident took place on Tuesday, October 14, 2025 at 8:17 a.m. at Sandhills Community Pharmacy on Ramsey Street. Caroline had been there once the night before and had called twice after closing because her husband's blood thinner had not been released after a hospital discharge. By the next morning, she had slept less than 2 hours. That was context, not permission. Security video showed her waiting 41 minutes at counter 3. It showed her checking her phone, stepping out of line for one call, then stepping back in. At 8:17, Nina came to the counter and explained that the discharge order was incomplete and the pharmacist needed one final confirmation from the hospital. Caroline said, "My husband is a lieutenant general. He cannot be told to wait while you lose his medication again." Nina said Caroline's voice rose quickly after that. Caroline moved past the rope line, came around the side of the counter and reached for the white prescription tray on Nina's station. Nina stepped in front of it. Caroline shoved forward with both hands. Nina's left wrist hit the edge of the counter. A barcode scanner fell and cracked. 3 filled prescriptions spilled across the floor. An elderly customer rose too fast and had to catch himself on a chair. When deputies arrived, Caroline was crying. A customer named Earl Benson, a retired staff sergeant, said she kept saying one line under her breath while the deputies separated her from the counter. He said she kept saying, "Do not call my husband. He did not do this. I did this." I remembered that later. It did not settle anything by itself, but I kept it. The charges were simple assault and disorderly conduct. The damage to the scanner and ruined medication batch came to $240. Nina's urgent care visit, brace, and lost wages came to $486. The state could have asked for jail time. A lot of people in that county expected it. People do not like it when status tries to go first in a place where everybody else has already been waiting. Neither do I. But the law gave me a tool I was glad to have. In our court, even on a misdemeanor, I can continue sentencing and order a presentence investigation if I think the charge sheet tells me what happened, but not enough about what should happen next. At a kitchen table, I would explain it this way. Sometimes the file gives you the damage, but not yet the right repair. Discretion in that moment meant I was allowed to look at more than the loudest fact. I could consider the harm, the record, the victim's position, the medical strain in the home, the treatment already started, and whether there was a sentence inside the law that would demand more from Caroline than a short stay in jail would demand. Discretion is not a loophole, it is responsibility with a narrower margin for error. I watched both women each time they entered after that. From the bench, you notice patterns. Caroline always walked in too fast and sat down too suddenly, as if her body had not yet caught up to the pace a courtroom requires. Nina always entered with her papers already in order. On the second hearing date, Caroline looked first toward the gallery. Nina looked first toward the witness chair. Each woman knew where the difficult part of the room was. Turn 1 came from a sentence so plain another person might have missed it. Earl Benson took the stand on December 2025. He was 71, wearing a brown jacket with an old unit patch stitched back on badly. The prosecutor said what he noticed most after the shove. He said, "She looked at that young woman's wrist and her whole face changed before the deputy ever touched her shoulder." He was not saying she was innocent. He was not saying she should walk away. He was giving me one clean human fact from the middle of a bad moment. Shame reached her before punishment did. That mattered. Until then, I had been reading the case like a list of damage. After that sentence, I started reading it as damage done by a person whose worst act had not burned every other part of her away. The presentence report arrived a week later. Most of it was ordinary: work history, marriage length, medical records for General Mercer, statements from a home health nurse, medication schedules, counseling records showing Caroline had started treatment on October 28th, 2 weeks after the incident and before any plea had been entered. People who think they did nothing wrong do not usually begin that work so early. The piece that stayed with me was a red spiral notebook marked as Defense Exhibit C. It was a medication log from the Mercer home. Every page had times written in black ink. 5:30 a.m. blood pressure, 7:00 a.m. dosage with food, 9:10 a.m. confusion episode, 11:40 a.m. call from cardiology, page after page, not neat enough to be staged, not clean enough to be performance, just used, factual, daily work. Subscribe. I am still thinking about what this case taught me. Subscribe, because before this video ends, I am going to try to say it out loud, and I want you to be here when I do. Subscribe now. Then came turn 2. The defense introduced a worn manila folder from the Cumberland Family Caregiver Resource Program. Inside were attendance sheets, intake notes, certificates from an 8-week caregiver burnout class, proof of 6 de-escalation sessions, and supervisor reports from volunteer hours Caroline had already begun serving while awaiting sentencing. She had not asked to work in an office away from the public. She had asked to work intake, where people arrived tired, scared, late, embarrassed, and sometimes angry. The folder itself mattered to me. The edges were bent. The pages had been hole-punched, taken out, and put back in. Physical things tell the truth, too. People who were staging reform like crisp papers. These were handled papers, working papers. One supervisor note dated January 9, 2026 said Caroline had spent 3 hours helping 2 older caregivers complete transportation forms after the office printer failed. Another said she had asked staff not to use her husband's rank because it made other families less likely to talk freely around her. When that line was read aloud, Nina stopped writing and lifted her eyes for the first time that morning. She looked straight at Caroline, not with softness, with attention. That evidence showed me not only who Caroline had been, but who she was capable of being if the sentence demanded it. And because the law let me suspend part of the sentence and review compliance later, I now had a lawful path to design something exact. Before that folder, jail and a fine would have been the easiest clean answer. After it, the easiest answer no longer looked like the right one. The defense did not waste time pretending rank had nothing to do with the offense. David Chen, her attorney, said, "My client used status like a tool that morning. The court should not ignore that. I am asking the court to sentence the person who has spent every day since then trying to become useful in the kind of room where she failed." That confirmed something I was already beginning to see. He also got one thing wrong. He leaned too hard on exhaustion and not hard enough on choice. Plenty of tired people do not shove workers. Plenty of frightened spouses do not say the kind of thing Caroline said. Fear explained the speed of the collapse. It did not explain the shape of it. Privilege shaped that. The defense needed to admit it more fully than it first did. When Caroline testified, she did not sound polished. More than once, she corrected her own lawyer in ways that made her look worse. When he said she had reached past Nina, Caroline turned and said, "No, I shoved her. Please do not say it's smaller than it was." I watched the prosecutor stop moving his pen. Later, when she was asked what her life had felt like that week, she said, "I had started thinking in 15-minute blocks. Pills, calls, food, sleep if I got lucky. Then one thing went wrong, and I acted like the world owed me a door." That was the quote that told me the truth about her circumstances. But it was not the line I wrote down. Near the end, I said what accountability should look like if I decided jail was not the only tool I had. She looked at me for a long second and said, "If there is a room where people wait scared and tired the way I was, put me in that room and let me help." That was the moment I knew what I was going to do. I wrote it down. Not because I needed to remember it, because I wanted to. Subscribe. Because if this case surprised me, and it did, more than once, I think what comes next will do the same for you. Subscribe and stay with it. Her final quote mattered too. The prosecutor said why she had used her husband's name at the pharmacy. Caroline did not dodge it. She said, "Because I thought that name would move people faster than mine would, and I used it that way." That was not graceful. It was accountable. There is a difference. Her testimony brought back a memory I had not visited in years. I was 12 years old, standing in my parents' kitchen at 11:20 p.m., in socks on cold linoleum. My mother was at the table in a gray robe with my grandfather's pill bottles lined up in front of her. One cap had rolled under the radiator. She was using a butter knife because she could not find the splitter. The radio was on low. She looked up once, and what I saw on her face was not anger. It was fatigue so complete it had gone quiet. I do not tell you that as a lesson. I tell you because it came back into the courtroom with me, white pill dust on the table, my mother's hair coming loose, the clock over the sink moving 2 minutes at a time. Then it was gone, and I was back on the bench looking at Caroline Mercer. By sentencing day, January 22nd, 2026, I had made the decision in substance. What remained was the exact shape. A sentence like the one I intended cannot be improvised. It has to be built. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. The room that morning had a particular kind of attention in it, not silence. Paper still moved. A cough still came from the back row. A deputy shifted his weight by the door, but people were listening with their whole bodies. Caroline had both hands flat on the defense table. Nina had her folder closed. General Mercer sat in the second row with a cane across his knees and stared straight ahead, as if he knew enough to stay out of the way of what had to happen. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I told Caroline to stand. I said, on the charge of simple assault, I am entering a 60-day sentence, suspended for 18 months of supervised probation. I am not sending you to jail today because I do not believe a short stay in a cell will teach you more than a year and a half of exact, public, accountable work will teach you. But the suspended sentence remains. If you fail this plan, the wall is still there. I said, I am ordering you to pay restitution in the amount of $486 to Nina Alvarez for medical costs and lost wages, and $1,240 to Sandhills Community Pharmacy for the damaged equipment and ruined medication batch. Money cannot repair dignity. It can repair bills. You made those bills happen. You are going to pay them yourself, not through your husband, not through a family account you do not manage, and not through anyone trying to clean this up for you. I said, I am also ordering 220 hours of restorative service at the Cumberland Family Caregiver Resource Program, specifically in intake, patient navigation, and waiting room support, not in a back office, in the exact place where people arrive tired, confused, and sometimes sharp with fear. I am ordering that because what happened here was not only an injury to one wrist. It was a failure to recognize the humanity of a worker under pressure. You are going to practice that recognition until it becomes habit. I said, you will complete 12 additional counseling sessions focused on caregiver strain and anger regulation, and you will file proof with this court every 30 days. The evidence showed me that isolation and over-control helped build the collapse that morning. If you try to carry everything alone again, you will return to the same edge. I am not willing to ignore that. I said, there is one more thing. For 12 months, you will attend one military caregiver support meeting each month, not as a name, not as a rank, and not as a spouse to be deferred to. You will sit in the circle as one member among others, and once each quarter, you will complete one Saturday shift at the county legal aid clinic helping older adults with benefits and medical forms. You use status to separate yourself from other people. This part of the sentence is meant to reconnect you to them. Then I gave the benchmark for early completion. I said, if by the 9-month review you have completed every service hour, paid full restitution, finished all counseling, and received 2 written compliance reports showing punctuality, humility, and reliable work, I will consider reducing the remaining probation term by 6 months. Courts should name the path when there is one. That was the clearest way I could say what I believed without turning the bench into a place for sentiment. I will say it plainly here because it is true. I believe she could do it. Then I spoke to her directly. I said, Mrs. Mercer, what you did at that pharmacy was not small. You used fear, fatigue, and borrowed rank to force your way past a woman doing her job, and you left real injury behind you. Nina Alvarez went home with a brace on her wrist and a reason to wonder whether ordinary public work had made her fair game for somebody else's bad hour. I looked toward Nina then. I said, to the people harmed by this, especially Ms. Alvarez, this court sees the cost in plain terms. Lost wages matter. Pain matters. Being treated as if your place in line did not matter also matters. Then I turned back to Caroline. I said, "The charges against you contain what you did. They do not contain everything you are." And I ended this way. I said, "Do not waste the grace of a structured sentence by treating it like relief. Treat it like work." The first reaction I noticed came from Nina. She did not cry. She did not smile. She exhaled once, put her palm on top of her closed folder, and gave one small nod without looking around the room. That was all. I did not need more than that. Subscribe. I am about to tell you what happened after the sentence, whether this person did what I believe they would do. Subscribe so you are here for that part. It is the part I care about most. As the courtroom began to empty, Caroline did one thing I watched closely. She did not turn first to her husband. She did not turn first to her lawyer. She turned toward Nina and waited until the bailiff gave a small nod. Then she said, "I will do every hour." Nina said, "Start by coming on time." That exchange took less than 5 seconds. Before I stood, I put the cap back on my pen and laid it across the docket. Small things feel different on certain days. On that day, it felt like finishing a careful piece of work with a steady hand. What happened after is not a neat success story, and I am not going to force it into one. What I know is this. On March 3rd, 2026, Nina's letter reached my chambers through the clerk's office. It said Caroline had completed 137 of her 220 service hours. It said she had missed no shifts. And it said, "She comes early now, and before the doors open, she straightens the chairs for the people who can't stand long." No appeal was filed. The order stood as entered. My honest response to that is simple. I was relieved, not because I thought I would be reversed, because it meant the sentence had been understood by the people closest to it. What I came to believe because of this case is simple. Mercy only means something when it asks more of a person, not less. It would have been easier to impose a short jail sentence, enter the fines, and move to the next file. That would have looked firm from a distance. It would also have left untouched the exact part of Carolyn that needed to change. Vague mercy says, "I hope you do better." Precise mercy says, "Here is how, here is where, here is when, and I will be checking." If you have been in Caroline's place, if you have done real harm and are wondering what I look for from the bench before I choose less than the maximum, I can tell you. I look for accuracy. Not tears by themselves, not polished regret. Accuracy. I listen for the moment a person stops shrinking what they did and names it at full size. If you know that matters, start there. Tell the truth without sanding it down. If you have been in Nina's place, if someone hurt you and the people around you expected either rage or silence, I am not going to tell you what to want. I can only tell you what I have witnessed when victims choose mercy with open eyes instead of pressure. It does not erase the harm. What it sometimes does over time is return a little control to the person who first lost it. I have seen that. I do not offer it as a rule, only as witness. One more thing from Nina stayed with me. In the last line of her letter, after everything else, she said, "I did not need her to suffer in front of me. I needed her to become useful where she had once made things harder." I have carried that line with me ever since. She comes early now. She straightens the chairs before the doors open. She makes room for people who cannot stand long. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. And if you leave a comment, leave it like someone making room in a waiting room, with enough care for accountability and humanity to sit beside each other without either one being pushed out of the chair.